roll call to establish quorum.
Thank you.
So Dolores Trujillo present, Vice President Mary Fagan.
Mary Fagan present.
Elizabeth Woods.
Woods present.
Jovita Dominguez.
Jovita present.
Patricia Nguyen.
Nguyen present.
David Lawler.
David present.
And Vicki Granowitz. And has Reza been elevated?
He is elevated. If you can check. Thank you.
Okay.
This is Reza. I'm here.
All right, great.
Thank you.
Thank you. Okay, we have a quorum. So let's finish out the indirect impact bills. The next
This
bill,
meeting is being recorded.
The next bill is AB 1007.
Okay. So this bill, excuse me, the tail end of a cold, I apologize. This bill would require the Department of Industrial Relations, Division of Occupational Safety and Health to submit to the Occupational Safety and Health Standards Board a proposed regulation requiring a health facility to evacuate or remove plume through the use of a plume scavenging system in all settings that employ techniques that involve the creation of plume. The bill would then require the division, when developing regulations, to consider, among other things, recommendations on the evacuation of plume from the federal OSHA and National Institute for Occupational Safety and Health. Lastly, the bill would require the Occupational Safety and Health Standards Board to adopt the proposed regulation by January 1st, 2025. And for those of you like me who did not know what plume was, it is a surgical smoke that is a byproduct produced during surgical procedures that involve heat generating devices such as lasers, electrosurgical units, high-speed burrs, drills, and saws. The smoke can contain toxic chemicals, infectious particles, and gases, which can pose a threat to healthcare workers and the patients.
So, we're seeing a lot of laser surgery and electrosurgery procedures taking place now. So this, it's safer for patients, right? In most cases, they're less invasive. And, but unfortunately, there is a plume that arises from that laser or electrosurgery instrument cutting the flesh. So our nurses are increasingly exposed, and our patients are exposed also. So this surgical smoke can release toxic chemicals, gases, vapors, and particulates, in addition to infectious particles and possibly even malignant and viable cancer cells. So this is in the interest of also not only protecting the nurses, but protecting the public. Is there any questions or comments from the board? Seeing that there's, oh, go ahead.
Was that a motion, Dolores? Because I'll second it.
Okay. Well, I will formally make a motion. I would like to make a motion to support this bill. And Vicki, you second it?
Yes.
All right. Thank you. All right,
So I
next bill.
Yeah, the next one is AB 1156, is that correct?
Yes.
Okay. So this one is related to workers' compensation and rebuttable presumptions. And I'll give a little background on what that is as well. So as you may know, workers' compensation is a form of insurance that provides medical benefits and wage replacement to an employee who's injured in the course of employment. A workers' comp rebuttable presumption means that the illness or injury is presumed to be caused by the nature of the employee's work unless proven otherwise by the employer. So the presumption means we're presuming that it happened in the workplace. Rebuttable means it can be refuted then by the employer. So for the purposes of workers' comp, existing law creates a rebuttable presumption of injury for various employees, including an employee who works at a health facility to include an illness or death resulting from COVID-19, if certain circumstances apply. This bill would define injury for a hospital employee who provides direct patient care in an acute care hospital to include infectious diseases, cancer, I'm going to mess this up, musculoskeletal injuries, post-traumatic stress disorder, and respiratory diseases. This bill would include COVID-19 and its variants, among other conditions, in the definition of infectious and respiratory diseases. The bill would create a rebuttable presumption that these injuries develop or manifest in a hospital employee who provides direct patient care in an acute care hospital that they arose out of and in the course of employment. And the bill would extend these presumptions to a hospital employee following termination of employment for a period of 3 calendar months for each full year of employment, not to exceed 120 months, beginning with the last day actually worked in the specified capacity.
It's amazing to me that we do not, after coming through a pandemic and serving on the front lines of that pandemic, that we are not eligible for workman's comp for our possible exposure on that front line. So some of the workers that are eligible for workman's compensation, EMTs, paramedics, firefighters, police officers, they are all eligible for presumptive eligibility, except nurses. And nurses need to be protected too. So,
Dolores, where does the protection for those others come from?
workman's comp. They're all eligible for workman's comp.
But nurses are eligible for workers' comp.
If it's an actual injury. At this point right now, COVID-19 is not covered for workman's comp.
But you say it is for paramedics and firefighters?
It is for paramedics, it is for firefighters, police officers.
And so where does that come from? Is there some special legislation for them, or I'm just not understanding how it would be different?
I believe it ties to the rebuttable presumption. And I'd have to do some more digging on this, but I think there's certain professions like firefighters and whatnot, where in law already there's an assumption that if they acquire certain illness, injuries, and whatnot, it came from their place of employment. So it takes the burden of proof that it was employment related off the employee. Yes. And so that's where the difference is it's changing kind of the burden of proof, not the eligibility for workers' comp.
All right, thank you.
I guess my concern again is the whole thing about hospital employees. Because we all know that all nurses don't work in hospital. They could be outpatient, they could be home health, they could be hospice, there could be many number of places where they work. That's not a hospital per se. And they, of course, have been exposed to COVID through their experiences.
I believe the bill describes it as healthcare settings. So I guess it doesn't have to be in a hospital. I'd have to pull the bill up.
Yeah.
But nonetheless, I mean, just an example is COVID. You know, and long COVID, which we're finding out is an issue coming out of having COVID. And for a lot of these nurses, they were exposed on the front lines.
So the bill states it's in the case of a hospital employee who provides direct patient care in an acute care hospital. The term injury, it manifests during the period of the person's employment. So it is a little bit more narrow around a hospital employee who worked in direct patient care in a acute care hospital.
That's not acceptable.
But I think it's a start, Betty. I agree. I agree with you. But I think it's a start. This bill appeared last year and it didn't go anywhere. So I would like to make a motion to support.
And it's Vicky.
Thank you, Vicky. All right, moving on to the next bill.
So I believe the next one was AB 1690 that was called out. Is that correct? Or no?
No.
That is still
That's spot.
no. Okay, it is. I was going to say I may have misheard. I was going to say it is still a spot bill, so there's not really
Yeah,
much
it's still
to
a
discuss.
spot bill, so no, we don't need to read that one.
Perfect. Okay. So then the last one I believe I heard mentioned was SB 636.
Correct.
Is that correct? Okay. So this is another workers' comp related bill. And it has to do with utilization reviews. And what those are is an insurance company's use of a medical professional to review, approve, modify, or deny treatment recommendations that are made by a doctor who interviewed or examined the patient. And the review is based on what the insurance company considers to be medically necessary. So this bill would require for private employers that utilization review for workers' compensation cases be conducted by a medical professional that is licensed in California. So it would require a psychologist who conducts a workers' compensation utilization review to be licensed by the California Board of Psychology and a physician to be licensed by the California Medical Board. The bill also clarifies that certification for disability benefits can still be established by a medical professional that is not licensed in California. And so I was able to do a rapid obtaining of the fact sheet during lunch on this one to get kind of the intent behind it. And the reasoning is that under current law, insurance companies may employ medical professionals that are licensed in any state to perform the utilization review. So as a result, medical professionals not licensed in California are exempt from regulation and discipline by the California licensing bodies. So if these medical professionals wrongly modify or deny claims, there's no regulatory structure to hold them accountable. And so there's the desire to make sure that the only ones doing it are licensed in California and are under our jurisdiction.
Got it. Any questions or comments from the board? You know, I would like to put a motion to watch this bill. See if more comes out of it.
This is Tricia. I'll second it.
Thank you, Tricia. All right. Are there any more comments or questions before we go out to public comment? Seeing that there's no further questions or comments, BRN moderator. Let me recap. AB 747, we are supporting. AB 977 is a support if amended. This is the ER assault and battery bill. AB 1001 is the behavioral health bill, and that we're supporting. AB 1057 is the home visiting program for pregnant moms and moms who have just given birth, and we are in support. AB 1007 is the surgical plume bill, and we are in support. AB 1156 is the workman's comp for nurses, and we are in support. And then SB 636, we will watch. Do I have it correct? All right. BRN moderator, can you please open it up for public comment?
public comment now. I will be activating the question and answer feature. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate that they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." Carmen Costi would like to make a comment. 1 second, please. Sorry, Carmen Comsti.
Good afternoon, and thank you all again for the robust discussion on bills. This is Carmen Comsi with the California Nurses Association. We'd just like to express our support for a number of the bills that you all just discussed on indirect impact. For AB 747, CNA is proud to be a sponsor of this bill. As was discussed, the previous legislation had been passed to ban employer debt traps for nurses and other direct care workers who are required to attend training by their employers, but then required to work for 1, 2, 3 years, or else repay that employer mandated training. However, we've had difficulties enforcing that law. So this bill, AB 747, would correct some of the issues that we're seeing and enhance Labor Commissioner and Attorney General enforcement, as well as cover more workers other than just nurses. And it's super important because we've seen that when employers hold workers hostage as debtors, it makes it difficult for nurses in particular to speak out about unsafe working conditions and to advocate for their patients for safe and effective nursing care. In a survey that CNA took last year, over 1/3 of nurses in training debt traps felt restrained from complaining about unsafe or unfair working conditions and unsafe staffing. So it's very important to make sure that employers aren't trapping nurses, particularly new grads who may not be familiar with the appropriate staffing levels in hospitals, or or may fear speaking out about unsafe working conditions. CNA also supports and is a sponsor of AB 1001, the Behavioral Health Emergency Services Bill, to ensure that we have the psychiatric registered nurses and other behavioral health staff necessary to help patients that are experiencing behavioral health emergencies in hospitals. We are also a sponsor of AB 1007 on occupational safety and health standards on surgical smoke, and we've been asking Cal OSHA for over 5 years to pass a health and safety standard on surgical smoke, and Cal OSHA has actually they've unanimously granted our petition to pass a standard, but we've been waiting since 2018 for a standard to actually be promulgated and voted on by the Standards Board. And we also are proud sponsors of AB 1156 on workers' compensation for hospital employees for presumptive eligibility for illnesses and injuries like MRSA, bloodborne pathogens, TB, meningitis, COVID, respiratory diseases, musculoskeletal diseases, and PTSD, among others. It's important that nurses get these presumptions so they don't have to jump through hoops to get their workers' compensation benefits, including time off, so they can heal and make sure that they aren't going back to work and further injuring themselves or exposing others to infectious diseases, and that we keep our nurses healthy and safe so that we're not losing nurses from our workforce. Thank you again. And I look forward to the robust discussion about all the other bills that are before the BRN this year.
Thank you. Board President Trujillo, there are no other public requests for comment. Would you like me to close this window?
Yes, thank you. All right, we'll take it to a vote. Dolores Trujillo, and this is for all the motions that we put forth on these indirect impact bills that we talked about. Dolores Trujillo votes yes. Vice President Mary Fagan?
Are we going to be able to vote for them separately in the future?
Is there a bill that you have concerns?
I was concerned. I mean, I just want to learn more about some of them. I feel like there's some that I just don't know enough about, like the behavioral health one that was a direct impact. And then,
abstain. If you want to not vote for any of them today, of the indirect impact, all the direct impacts have already got a vote and are completed. These are indirect impact bills that were not part of the regular preparation, were pulled forward to be discussed by our board president and by Betty. So if you do not want to vote, you can choose to abstain, or you can choose to have a yes vote registered in favor of all of the positions that the board is taking, and pull out any particular bill that you want to do a no vote to.
we'll
And as our amendments are made, they're going to come back.
come back. Okay, we'll have other opportunities to weigh in. And you know what? I probably should abstain because I was pulled away and I had to miss some of them. So I'll abstain for now, but hopefully we'll have a chance to learn more about them as we move forward.
Okay.
Thanks.
Sure. Elizabeth Woods?
Woods, yes.
Jovita Dominguez?
Yes.
Marissa Clark, sorry. Trisha Wynn?
Win, yes.
David Lawler?
David, yes.
Vicki Granowitz?
Granowitz, yes.
All right, motion carries. Thank you. Item 6.0, and this is information only. Presentation by the BRN's Enforcement Division on discussion of the board's recommended guidelines for disciplinary orders and conditions of probation. And these are disciplinary guidelines. This is Shannon. Hi.
Good afternoon.
Thank you.
So I'm Shannon Johnson. I'm the Enforcement Division Chief, and I'm going to be presenting an overview of the enforcement process today. I'd love to answer any questions you guys have. If you could wait maybe until the end so we can get through the presentation. Next slide. So today, the objectives, we're going to do an overview of the enforcement process, what triggers a complaint, what to expect in the disciplinary proceedings, and then also a little bit touch on the disciplinary guidelines and how this the enforcement process works with the disciplinary guidelines. These are just some of the common terms that are used in enforcement. The respondent will always be the RN or the applicant. The complainant is always going to be the board's executive officer. The Office of Attorney General is the body that prosecutes the board's cases. The Deputy Attorney General, or the DAG, is the attorney that's assigned to prosecute the case. Our cases are heard by an administrative law judge in the Office of Administrative Hearings. A statement of issues is the pleading that's filed for an applicant. The ISO is our interim suspension orders that get processed through the administrative court. Penal Code 23 is what gives the board authority to ask for a suspension or conditions be placed on a license until the conclusion of the criminal proceedings. And we'll talk about the two emergency orders that I just mentioned in upcoming slides. Next. So we have several units within the enforcement division. We have complaint intake, discipline, probation. They're all units that are part of the formal disciplinary process. The legal desk processes all of the disciplinary actions and monitors payment of cost recovery and fines. The decisions and appeals is not a unit within enforcement, but it processes all of the appeals to our disciplinary actions. And of course, I'm sure, as you know, it processes all of the board voting for the adoption of decisions. The citation unit handles non-formal complaints. The intervention unit, intervention is our program for nurses that suffer from substance abuse disorder or mental health illness. It's not considered enforcement, but it is housed under the enforcement umbrella. And then we also have our investigations unit, which isn't part of enforcement, but works closely with the enforcement division in investigating all of our cases. So throw this in there, just Business and Professions Code is our public protection mission. And so pursuant to that code, the protection of the public is the highest priority of the Board of Registered Nursing. Next. We're going to start with complaint intake. I'm going to go through these units. It's kind of how the case flows throughout our enforcement division. So the very first point of contact is our complaint intake unit. So what triggers a complaint? The caseload that comes into the complaint intake unit consists of licensees that are arrested, convicted, public complaints of alleged unprofessional conduct, incompetence, negligence, gross negligence. We also receive applicants from our licensing unit that have either disclosed another disciplinary action against a healthcare license or have disclosed criminal history. Even if the criminal activity is not disclosed, it may come up during the fingerprinting process, and that is supplied to the board, the fingerprints at the time of application. Next. We receive complaints from many different entities, such as patients, families, employers, other state agencies, law enforcement, all of our public complaints, everything outside of an applicant or a conviction, those are all considered public complaints. So that umbrella houses many different types of complaints that come in. Next. So all of the public complaints, they need to go and undergo a desk investigation. The desk investigation is conducted at the complaint intake level. And this is the part of the process in where we retrieve any evidence to determine if a field investigation may be needed. And we do also take into consideration anonymous complaints. We do get a lot of anonymous complaints, and as long as we have enough information to go on, we will also investigate those. We'll do the desk investigation to try and identify needed information, and then if needed, we'll move it on to a field investigation. The board doesn't require a complainant to identify themselves. However, if we're not able to obtain that pertinent information during the desk investigation, we may need to close the complaint as insufficient evidence. This may also be the case where the complainant can't provide a nurse's name, any identifying information, and the board can't identify. So if the board can't identify or verify the respondent is a registered nurse, we'll have to close that as well as insufficient evidence. Non-jurisdictional complaints are those that are either licensed by another board or agency, example being BVNPT or Department of Public Health. We have confirmed that the board doesn't have jurisdiction over the case. Example would be in where an RN is alleged to have been rude, or the RN has a dispute with a neighbor that's not criminal in nature. We do get a lot of complaints about rudeness, and unfortunately, we don't have jurisdiction over someone's personality, only their scope of practice and their criminal activity. Next. So in Business and Professions Code 129, it mandates that every board notify a complainant within 10 days of receipt of a complaint when the complainant is known. So this means that the board has to move rather swiftly on complaints that are either entered into our BREEZE system, on those complaints that are still sent in via mail. Due to mail processing times, it even gives us less time to be able to get that out within 10 days because it's 10 days from when the board receives it. So even though we may not receive it through our mail system internally for a few days, it has still come in, and it has to be 10 days from the date the board received it. And so we send notifications out of acknowledgement for every case in where the complainant is known. Next. Once it's determined that the case needs a field investigation, we send all of the cases over to an investigation unit. Next. So we have 2 investigation units for our cases. There is the internal BRN investigative unit, which they are all non-sworn, and they work most practice patient care complaints. There's also the Division of Investigation, DFI, and they're sworn law enforcement. They work the more egregious cases that have a criminal element or severe patient harm or death. So some of the causes for investigation, obviously patient care violations, narcotic diversion, if they've been arrested or convicted, intoxication on the job, all of the dishonesty, theft, fraud, shoplifting, which are criminal, even pre-charting critical assessments before the assessment's completed, changing the charting or attempting to cover up charting and fraudulent charting, falsifying any of the medical records. And then we also do get complaints of false ALS and BLS cards. Next. So once an investigation is complete, it's referred back to enforcement, where then an analyst then reviews it to determine the next steps. In practice cases where the allegations are substantiated through the investigation, we then send it to an expert for review. There are cases that if enough evidence is obtained and there is no scope of practice violation, for instance, drug diversion, an expert review is not needed for administrative prosecution, and the case can then be sent directly to the Attorney General's office. The investigation may also be referred to the local district attorney for criminal prosecution, should there be any substantiation of criminal activity. Okay, expert review. Next. So a current and inactive, to be an expert, the criteria for our experts is one, you have to have a current and active California RN license. You have to have 10 or more years of experience as an RN. You have to have 5 years of clinical practice experience in the area of expertise that you are opining in. And actually currently working in that setting as well. No prior or current charges or discipline against your license. No criminal convictions, including any that were expunged or dismissed. And then also you must be able to write complete and concise reports. We have a lot of people that apply to be an expert, and even though they have the expertise and the experience, the background, unfortunately, not everyone's a great writer. So we do go through a series of writing samples prior to bringing them on as well. Next. So all alleged practice violations are reviewed by an expert consultant. Reviews are conducted to determine whether the nurse's treatment and or their conduct met the accepted standards of practice or whether it departed from the accepted standards. So their findings could include no violation at all, unprofessional conduct, which would include incompetence, negligence, gross negligence. Next. So I'm going to break it down just a little bit. So unprofessional conduct, and I'll just kind of go through these a little bit more in depth, these slides. But under the Nursing Practice Act, we can take action for unprofessional conduct It's a finding of general unprofessional conduct. It may be appropriate where you find that the conduct doesn't constitute unprofessional conduct, but in the form of gross negligence or incompetence, and where the conduct does not otherwise fall into a category specifically defined as unprofessional conduct. For example, a single act of simple negligence, harassment of a coworker, inappropriate relationship with a patient, and so on. Next. Gross negligence is an extreme departure from the standard of care, which under similar circumstances would have ordinarily been exercised by a competent registered nurse. So that's defined under California Code of Regulation 1442. And such an extreme departure means that it's the repeated failure to provide nursing care as required, or the failure to provide care or to exercise ordinary precaution in a single situation which the nurse knew or should have known could have jeopardized the client's health or life. No actual harm is necessary here, only the potential to harm. Next. So gross negligence. So it's either a nurse's conduct and or treatment that can constitute gross negligence where the facts, as presumed, demonstrate there's a repeated failure to provide nursing care as required, or if their conduct or treatment can constitute gross negligence where there's a failure to provide care or to exercise ordinary precaution in a single situation, which the nurse knew or should have known could have jeopardized the client's health or life. Next, and incompetence. So incompetence, it's the lack of possession of or the failure to exercise that degree of learning, skill, care, and experience that would ordinarily be possessed and exercised by a competent registered nurse, and that is in CCR 1443 and 1443.5. So therefore, as defined, it's a nurse's conduct and or treatment can constitute incompetence in either one of these two ways. So the nurse does not possess that degree of learning, skill, and experience that is ordinarily possessed and exercised by a competent registered nurse, or it's the failure or the nurse failed to exercise that degree of learning, skill, care, and experience ordinarily possessed and exercised by a competent registered nurse. So those are the areas in which we find and will pursue disciplinary action. And those are the three areas in which our experts opine on and provide us a report, which we then send to the Attorney General's office. So which brings us to discipline. So if a violation is substantiated, the board pursues formal administrative action against the license. And this begins once we send it to the discipline unit. So the first order that I want to talk about is one of our emergency orders. So during the complaint intake process, if the board receives notification of arrest, it's of an egregious nature, the board has the authority to appear before the criminal judge and request restrictions be placed on that license. If the restrictions are ordered, they're only in effect as ordered by the criminal law judge and typically end once the criminal matter is resolved. A criminal law judge does not have the authority in the administrative side to pursue the suspension or the conditions on the license once the criminal proceedings have concluded. Once the judge places the restrictions, it is immediately posted to our board and to nurses. And in many cases, unfortunately, though, the restrictions are not ordered. And as you can see on the slide, some of the example cases are quite egregious. We probably get one a week, just to give you an idea of the types of these egregious cases that we do get. Because of the fingerprinting that the nurses do, if they're arrested for one of these acts, we get a rap sheet the very next morning. Within that day of receiving that rap sheet, we have this case already to the Attorney General's office for prosecution. A lot of times when the arraignment's coming, it's within, 24, 48 hours sometimes. So we have to move very quickly to ensure that we can get into that arraignment and request that suspension or conditions as quickly as possible. Next. The other emergency order that we have, unfortunately, when we don't get the criminal judge to impose the conditions or the suspension on the license through the criminal courts, sometimes we are able to try the interim suspension order. If we're to pursue an ISO, the case is referred over to the Attorney General's office, and the interim suspension order is requested in the administrative court by the administrative law judge. The thing about the interim suspension order is we have to have all of our evidence intact right there and then when we make this request. So if we don't have it, as you can imagine, on some of the arrest where there is an alleged egregious act, rape, murder, some of those violent crimes, at that time, it's still an allegation and they're still, they are entitled to their due process. So if we do not have evidence that they, in fact, committed those crimes and a conviction is proof thereof, other than that, we would have to have some other type of evidence. So if we can't get that PC-23 order and we don't have the evidence to move forward with an interim suspension order, we have no other means than to move forward with a field investigation to try and obtain any witness statements, subject statements, and any other evidence that we can obtain. Another order that we have, it's not an emergency order, but when it appears that the practice is impaired due to a mental or physical illness, the board may order the RN to be evaluated by a mental or physical exam. And that's in Business and Professions Code 820. The examiners that are obtained by the board for these evaluations need to meet the same criteria as mentioned in the expert slide previously. This exam may be used as evidence in disciplinary proceedings conducted if the RN is found unsafe to practice. An example, we have, a case where, police show up, the RN is arrested, and maybe there was, weapons involved, or maybe some illicit drugs involved, or, something along that nature. However, the RN doesn't get convicted. We do, if it does look like there may be a mental health issue, a concern with substance abuse disorder, things that would fall under 820, we would then use that to evaluate them. If the RN's found unsafe to practice, then we have the authority to file an accusation against their license to either revoke, suspend, or place it on probation, whatever is deemed appropriate by our disciplinary guidelines. If the RN is found safe to practice through that 820 exam, we close the case out. We have no further avenue to move forward with that case. Once the case is received from complaint intake, it's prepared by the discipline unit, transmitted to the AG's office, and that's typically within about 10 business days. The Deputy Attorney General assigned to the case then prepares the pleading or the order to compel. The order to compel was what I was just talking about, that Business and Professions Code 820. But the pleadings that they provide for us would be either an accusation for a licensee, a statement of issues if it is an applicant, or a petition to revoke if they are a probationer. The order to compel is for the evaluation for allegation of mental or physical impairment. So when I was talking about the 820, if they're found not fit to practice, then the attorney would then file an accusation using the unable to practice safely as the cause for discipline in that accusation. So for an accusation, the licensee has 15 days to file, we call it an NOD, Notice of Defense, and that is their appeal to their allegations. So an applicant, once they're denied, they have 60 days to appeal the denial of the license. Their appeal is considered like a notice of defense. All of these documents state the cause for action. So whether it be a statement of issues or an accusation, both will state the cause for the action. Or if it's a probationer for a petition to revoke probation, it'll state the violations of their probation conditions that they have violated. Sometimes we do it's a petition to revoke and accusation. That would just mean that they've not only violated conditions of their probation, however, we have a brand new violation as well, which would be the cause for the accusation. All of these documents, they are published public documents, and they get published to both our website and to nurses, except for the statement of issues. Those do not get posted. So respondent can choose to go to hearing. So if they do, a hearing date is set with the Office of Administrative Hearings, and the administrative law judge will hear the case. Once the case is heard, they have 30 days to provide us a proposed decision. The respondent, they may inquire about a settlement in lieu of hearing. That's another option. For settlements, they need to show proof of rehabilitation, letters of recommendation. If it was, scope of practice, they would need to have employment reviews. And all of this is listed as settlement requirements, mitigation that is needed. Those are all listed within the disciplinary guidelines. And the disciplinary guidelines kind of drive us into how we take discipline against a nurse or an applicant if we issue the license, probationary license. And it lays out, if you haven't had an opportunity to really look at the disciplinary guidelines, but it lays out every violation of the NPA and then what would be the appropriate disciplinary action for those violations. And not only do my analysts within the discipline unit use those when trying to determine settlement terms, but the administrative law judges also use those when writing their proposed decisions. Regardless, if it's a settlement or not, the board, carefully considers the totality of the facts. Again, totality of the facts, we use the disciplinary guidelines in order to try and make those determinations on the outcomes. Oh, the possible outcomes of cases would be one, a public approval. So this is the lowest form of formal discipline. This usually includes cost recovery for the investigation, the cost of the investigation and the prosecution cost. And it could possibly include courses, depending on what the violation is again. You have probation, and this is typically a 3-year probation term and applies the conditions dependent again on the causes for discipline. And then, of course, we use the disciplinary guidelines. With probation, it's typically 3 years, but this could fluctuate. For instance, if you have someone that's on a criminal probation, we may try to mimic that criminal probation and extend the probation out slightly longer, just to make sure that if they happen to violate their criminal probation, they're still under our probation, and we kind of have that covered jurisdictionally. We have surrender of license. So if an RN surrenders their license, they need to wait for 2 years to petition the board for reinstatement of that license. If they surrendered their license because of a mental or physical illness, they would only need to wait 1 year for petition eligibility to petition the board for reinstatement of their license. We have a revocation of license as an outcome. So a revocation can happen 2 ways. It could either be by default, which means that the RN did not respond once the accusation was filed with their notice of defense, or if it went to hearing after the administrative law judge hears the case, they may order a revocation. And so if that happens in either case with a revocation, they would need to wait 3 years before they are eligible to petition the board for reinstatement of their license. And if it's an applicant, the final order could be just outright denial of licensure. And this could happen if either they did not appeal, so that if they didn't appeal within that 60-day time frame, or if it was ordered by the administrative law judge. In any of these cases, if they go to hearing or choose to go to hearing, also we would do a revocation, a default revocation if they were a no-show to their hearing. We could possibly withdraw the pleading and no disciplinary action taken based on additional mitigation. For example, we recently filed an accusation against a nurse, come to find out that the reason or the cause for discipline was an out-of-state discipline. That out-of-state discipline was incorrect. And so it was a false claim. We withdrew the accusation and closed the case out. So then we remove everything. If that's the case where we're withdrawing, we remove it from our website. We remove it from Nurses. So recommended guidelines for disciplinary orders, which I've touched on, but this is kind of, the go-to document for us. Recommended guidelines for disciplinary orders and conditions of probation, which we just call them disciplinary guidelines. It includes the violations and the recommended actions. It includes all of your mitigation for rehabilitation and conditions of probation and all the rationale. So all settlements that are either negotiated prior to hearing as a stipulated agreement or the proposed decision by the administrative law judge after hearing, they're all made pursuant to those recommended guidelines for disciplinary orders and conditions of probation. And the guidelines are for the purpose of guiding the judge or the BRN staff in applying the appropriate discipline to each violation. So it gives a minimum and a maximum for every violation that we have. So that disciplinary guidelines is really important. And part of the reason that we're going over them now is we're looking at revising them, making some edits and updating them. Also with the newly created NMAC and NPAC committees. They are also looking at possibly having some input into those disciplinary guidelines. So I think it's really important to understand why we have those in place, what they're used for, who uses them, and how they apply through our disciplinary process. So if a nurse, a licensee, is placed on probation, or if an applicant is issued a probationary license, we put them in our probation program. Next. So the purpose of probation is first and foremost to just ensure public protection, which of course the entire board's mission is, protecting the public, but while enforcing all of the conditions that we impose during their probationary period. So we try to ensure that probationers have the tools to comply with their conditions and at the same time take any actions. Additionally, if there's either a violation of one of their conditions or if there's any subsequent violations, like I'd mentioned earlier. So for instance, if a probationary nurse, one of their conditions is they have to inform us if they break any laws, state, local, federal laws. So if they're arrested and they don't notify us within that time frame, they now have a new accusation, and now we have grounds for a petition to revoke their probation based on violations of their probation conditions. If a probationary case is sent back to the Attorney General's office for further action, they would go through the same disciplinary process as we do for initial cases. And of course, allowed due process, just like any nurse that we prosecute the license, everyone is awarded their due process. Next. So within the disciplinary guidelines, you're going to find all of the conditions of probation. The first set of conditions, we consider them the standard conditions. and they appear in every probationary case. So as you as a board get your cases to vote on, and it's a probationary case, you'll notice that most of the ones that are a violation of employment, where it's scope of practice related, incompetence, negligence, gross negligence, they're always going to have the first 13 conditions. The only time that doesn't apply is if it is a applicant who has been issued a licensee, a license, a probationary license. We do not charge them cost recovery. So that is the only condition that you will not find in the standard conditions across the board. And as you can see with the standard conditions, it's the basic supervision, your employment limitations, functioning as a registered nurse, whether or not you leave the state or come back into the state, any courses that you may need to take in your cost recovery. So that's all encompassed in those standard conditions. Next. So we do have a set of conditions. The second set of conditions are optional conditions. That may be applied if there's substance use, mental illness, conviction where we feel that there's some additional monitoring. That includes your physical, mental health evaluations, whether or not you have to participate in a rehabilitation program, whether it be intensive, outpatient, inpatient. We have you abstaining from all psychotropic mood altering drugs and submit to fluid testing. We also now do hair, nail testing, and blood. And then therapy. And we can also impose an actual suspension of license. The suspension of license we use a lot when we have a case where it is questionable whether the nurse is safe to practice or not. So what we'll do is we will put language in there that will suspend the license until they can have the mental and physical exams completed to ensure the board that they are safe to go back to practice. As I mentioned before, noncompliance with any of the conditions of probation results in further action or may result in further action against the license. It could be a cease practice. So for instance, if we find that they have tested positive for a substance which they do not have a valid prescription for, we do a cease practice immediately. It could be a voluntary or stipulated surrender of license. They do have a condition within their probation conditions that allows them to at any time voluntarily surrender their license during their probationary term. We could do a revocation order by the administrative law judge after hearing. Some of our very minor violations, we would do an extension of probation. So for instance, if they couldn't pay their cost recovery or they couldn't comply with employment, they have to work at least 24 hours per week for 6 consecutive months. We do have clauses in both cost recovery and employment that if they can't meet that, we can do an automatic extension in-house for them up to 1 year to allow them to comply with those conditions. And then we have citations. And as I mentioned earlier, citations is not formal. It's when a case doesn't rise to, next slide, sorry. It's when a case doesn't rise to the level of a formal discipline, and we send it to our citation unit. And some examples of what we cite for are first time, very low level convictions, maybe like a petty theft, a very low level DUI, no aggravation. We have citations where we do for not updating your address of record, non-compliance with our fingerprint requirement, and some other issues. We did have like some falsification of ALS and BLS. Some of those are citations, not necessarily rising to the formal discipline level. There is an appeal process, both informally and formally for citations, that also allows them due process. So with our informal, so the violations, when they don't rise, we can do a fine up to $5,000 and or order of abatement. They can appeal. So their due process is they have the right to appeal within 14 days. There's two different types of appeals. They could do an informal conference. And then once the informal conference is held, we either affirm, modify, or dismiss that citation within 14 days of that informal conference. They also have the option to do a formal appeal within 30 days. In that case, and they don't have to necessarily do the informal conference, they can skip right to the formal appeal if they so choose, or they could do the informal and then go to the formal. They have that option. But the difference with the formal appeal within 30 days, the case is referred to the AG's office, and then they're going to request a hearing with the administrative Office of Administrative Hearings, so an ALJ can hear that case. It is then again either written up to affirm, modify, or dismiss. Unless it's dismissed, that citation becomes final. And one thing that's really important about citations, if they are upheld, an RN is not allowed to renew their license until that citation is paid in full. The one difference with a formal appeal versus an informal appeal is once it goes to the Attorney General's office and we go through that formal process, it now all becomes public. Citations are normally not, it's not published public record for 3 years. After the 3 years of final completion of that citation, whether it be a fine and or courses, we purge those records. But if you go through the formal appeal process, that is not the case. It does become public at that point. Next. So again, non-published public record. They have to provide a copy of the citation if requested. So we don't publish it. However, there's a flag if you go to look them up that says notify the board. So if they notify the board and request a copy of the document, we do provide them a copy of the citation. Again, they're purged 3 years from the date of resolution. Our unpaid citations, we send to the Franchise Tax Board for collection. Non-compliance also, like I said, will result in the fact that you will not be able to renew your license, but it also may result in additional formal discipline on the license. We also are in discussions right now with obtaining collection facilities. So for instance, if they live outside of the state of California and we're unable to obtain those fines through Franchise Tax Board, we will eventually have the option of going through collections to obtain those monies. Next. So enforcement data, I previously gave this presentation to both the NMAC and NPAC, and I know one of the things that they really wanted to see kind of a breakout of some of our statistical data. And it's really small. So I'm gonna try and help. I don't know if you guys can read this, but I took the last 5 fiscal years and I wanted to show the final outcomes. The first slide here is all of the nurse practitioners. So as you can see through the years, how many were public approvals, how many were probation, how many were surrendered, reinstatements, and so on. And then at the bottom of that where it says violation type, I tried to break it out for you so you could kind of see what types of violations were they that resulted in the, so for instance, if you want to look at last fiscal year, we had 14 practice related allegations. 6 of those ended in public approval. Well, they fall all over the place in here, but 5 were 801. So I separated out even the practice cases. So the regular public practice cases, and then 5 were 801 practice. So those were all of the insurance settlements that we get through the 801 filings. So I separated those out. So you could see that 6 of them, it's very small, 6 of them were out of state discipline. So it was another state took action on their license. So we then pursued that action as well. 12 were convictions. 6 of them had some sort of substance abuse disorder connected to it. So I just tried to give you an idea, and then you can kind of see throughout the last 5 fiscal years how they've been falling. And it's pretty similar if you look at the total numbers at the bottom. There's no real high spikes. It seems to really at the end of every fiscal year kind of really kind of maintain steadily through the years. Now you're going to see a huge difference when you look at the next slide, because the next slide are the nurse midwives. And of course, it's a smaller population of our certified nurse midwives. But as you can see, just this last fiscal year, we had 2 actions. One was a practice case, one was an out-of-state discipline. The out-of-state discipline, my guess is they probably reside outside of the state, so they just surrendered. That's what a lot of them do. And then one was placed on probation. And as you can see too, they've decreased as the years have gone. So it's dropped, you know, a third from 1920 to 21-22. The next slide that I put in here, and wow, you can really not see that one. It came out kind of light. But what this is case timeframes. And this slide depicts the amount of time a case is spent in each section of the process. So the intake time, it's that first column. I don't know if you can really see it. It says intake, the second column. It's the amount of time our cases are in intake, and that's prior to going to a desk or field investigation. The investigations section in that middle, it's the average amount of time for investigation. And this includes desk investigations, BRN field investigations, and D of I field investigations. So that's the average of all the investigations together. And then the post-AG transmittal, that last column, that post-AG transmittal, that is after we've sent it to the AG, that's the amount of time it takes to get a pleading, go to hearing, and then go to board for vote, and then get processed by our legal desk afterwards. So it's kind of, it's not as broken down, but the next slide I put in here, hopefully you can see it a little bit better. This is actually broken down. So right now I have an analyst that provides flow charts for me. We look at 18 months worth of data at every milestone of the case in investigations, from the time it comes in, from complaint intake all the way to the final disposition of the case. So as you can see, so for instance, complaints entered, it's taking us 4 days on average over the last 18 months looking at data. It's taking us 4 days to get a complaint entered. Getting the complaint to the investigation is taking us 8 days on average. The investigations time, and I separated them out so you could see. So BRN investigation time, it's averaging 167 days. D of I's investigation time is 267, which and D of I has gone down. They've really come a ways from where they were as far as their processing times. And I continue to work with them while we work together on trying to streamline all of that. Our expert reviews on average take 23 days. And that is the complaint and investigation process. Now, if you drop down to the bottom, this is the formal discipline process. So referral to the AG's office is taking about 16 days right now. I'd like to see it more, maybe around 10 days. Referral to pleading, meaning from the day we refer it to the Attorney General's office to the date we get them the pleading, whether it be the accusation, the statement of issues, it's taking 91 days. And it used to be a lot longer. They've gotten a lot better as well. Pleading to hearing. So from the time that pleading was filed, that accusation or statement of issues, until we get a hearing date. And we're kind of at the mercy of Office of Administrative Hearings on this one. But we're on average about 333 days. From the time getting the pleading filed, if we settle instead of going to a hearing, we're at about 198 days. And then the decision to the appeals desk, once the board votes on it and adopts it, we're taking about 9 days to get that processed. So as you can see, the areas that we do have control over, we're doing fairly well. There's only a couple areas that we don't have control over, and obviously that's field investigations and that's AG time, hearing time. So This is July 2021 through just this last December. I put some examples in here in the next slides, and I'm not going to go through them, but they're just some examples of some cases that we've received. And again, this presentation was for NMAC and NPAC, and they wanted to kind of see what types of cases we're getting. So here's a nurse midwife case. So between May and November, they have five quality events that were reported that raised concern about patient care. Performing water bursts, refusing to remove their hand from the, private area of the patient, allowing a patient to labor too long without assessing them. Next. They failed to timely notify the attending obstetrician and failed to transfer care of the patient with preeclampsia. So these were the actual allegations. These aren't the findings, just so you know. The 1 through 5 was the initial allegation of the complainant. So as you can see, 421, it was referred to a field investigation. 614, so it took us 14 months to get the investigation completed. It was sent for expert review within 4 days. Next. It was referred for prosecution in less than a month or so. We got the accusation filed within a couple months, 9, 10, 11, 3 months. Hearing date was set. As you can see, it took about 6 months to get the hearing. It got continued by the respondent. Therefore, it was extended out. We received the proposed decision, sent for board vote. You guys were real quick, got that back to us. And their probation was effective November 2nd, 2022. So that's the nurse midwife case. The nurse practitioner case, 2018, they were showing signs of possible impairment while at work. They did a 4-cause drug screen and it was positive for codeine. And I just want to make a point right here. We do get a lot of complaints. What's interesting is we have a lot of facilities that will file complaints. They never did a 4-cause drug screen. They allowed the nurse to leave the facility. We have no evidence at that point of diverting or being impaired on the job, especially depending on the type of substance they're using. For instance, we had someone who was diverting fentanyl or Dilaudid. It's very quick out of your system. You can't go back 3 days later and do a drug screen to find out if they were impaired at work or not. It just, that's just not going to work. So we had to do a field investigation. The investigation was complete. Looks like about a year after we received the complaint. And an expert wasn't needed because we had evidence of the positive drug screen at work. So that really, if we have an admittance by the respondent, we have a positive drug screen, there's ways we can kind of expedite that case without having to jump through additional hoops to try and prove the violation of the MPA. So this particular one, it was great that they did the screen because then we knew that they were impaired. They chose not to go to hearing, stipulated to a surrender of their license. So due process, it's still, I can't remember the beginning date of that, February 28th, 2018. So it looks like within a year, we had that surrender completed. So are there any, I know that's a lot of information, and believe me, I could probably talk if I went into depth on this stuff for a day. But I tried to cram it all into a short period of time. Any questions? Hey, Trisha.
Thank you very much. And Shannon, wow, that was really fantastic. I'm glad I got a chance to really get this primer after I've been reading cases for a while, because it really provided some context, which is going to be helpful going forward. But I kind of needed to just read the cases initially, just to kind of get my feet underneath me. I have 2 questions. The first has to do with the expert panel. So do people apply to become an expert, and then we have an existing list of experts that we draw from, and if somebody else needs an expert, they may draw from that list also?
So first, we implemented some years ago that we put on the renewal if they're interested in being an expert witness. We call them expert practice consultants. But they're not just based on practice. We have experts in other areas. But yes, we do pull experts in every arena. For instance, we need med spa experts. We need, oncology, geriatrics, NICU. We even need experts specific to the prison industry and, corrections. So we have experts in every field. So for instance, if a case comes in, and I'll just throw the nurse midwife. If it's a nurse midwife, we will only send the case to another nurse midwife. If it's a nurse practitioner and they were working in that advanced practice when the violation occurred, that expert is going to be a nurse practitioner. If it was a dawn, we try to send it to another director of nursing within that same type of arena. So yes, we do have a large pool, and we're always wanting more and more experts. We do have experts in the field of psychiatry, psychologists, mental health nurse practitioners, and that's for all of our substance abuse, mental illness, physical impairment, where we have to have assessments done. So they all have to meet a certain criteria, which is the 10 years in that, and as a registered nurse, 5 years in that field that they're opining on, currently working in that field, and that criteria that I went through in that previous slide.
Yeah,
We
thank
also we contact the medical board, the board of psychiatry, and all of them to try and obtain experts in those, from those boards as well. They've been helpful in posting to their websites for us and advertising. As you know, at the board meetings in the agenda item summary, I always have a list of those experts that are needed.
Yeah.
The licensee or the advanced practice where there's smaller, like nurse midwives, we don't have as large of a pool. Those are harder to come by.
Okay.
And again, it's also difficult because a lot of them know each other in that same arena. And so there's a conflict of interest. So then we have to be very careful who we send cases to. We have to ensure there's not conflict of interest as well.
Thank you. So I noticed sometimes, like in disputed cases, where the respondent, is that right? The respondent will bring in an expert. So
yes,
sometimes that expert isn't qualified, but are they eligible to use the experts that we have kind of recruited to be experts?
We have had in the past opposing counsel maybe pick up or try to pick up an expert that we've used in the past. They've done that. I know that we have certain criteria that we try to, not we try to use. We do use certain criteria. If opposing counsel comes into a hearing with someone who may not meet that criteria, then the credibility may be in question at that point. And I think that our DAGs, our deputy attorney generals, have in the past done a good job of trying to present that credibility and whether they not that their testimony should be considered as a high level as our expert.
Right. So I have seen that, Shannon. So I guess my question is, if they were to call us and say, we want to utilize an expert, could we utilize an expert on your list so that you couldn't really get the credibility? Are they really kind of on their own?
We don't provide experts for opposing counsel. No.
Okay. Thanks. Then my second question, I think this one's easier. So the cite and fine, I wasn't really aware of that process before today. So is that like you were speeding? I'm going to mail you a ticket. You can pay the fine and then it just goes away, or does it get reflected on the license somehow?
It's like an infraction. So, like a speeding ticket, like an infraction, it's a low level. It's not formal discipline. So like I said, say I pay my fine today, 3 years from today, all of that is purged.
Okay. Thank you. That's super helpful. Really great presentation. Thank you.
You're welcome. Yes, ma'am. Hi.
Oh, I have a question about the NCLEX exam. In the past few weeks, actually, two situations that I've seen going over the issues on nurses who've been disciplined, and they're sort of the same. There are nurses who were disciplined in California, but were able to get licensed in other states as RNs. And then all of a sudden, they wanted to come back and work in California. So they need to get their license back in California. These two particular cases, that these nurses were to redo the NCLEX exam. And I had a question about that, because they are working in other states as RN, so they passed the NCLEX somewhere.
Real quick, Betty, I just want to interrupt really quick. I'm concerned about the cases that you're talking about in a public forum. If they were sent to you for review, these might not be ones that need to be talked about in a public forum. So
I can speak in general.
We could speak in general here, but I'm going to ask that if as board members, you guys were sent cases to review or anything, that you not talk about them in a public forum as part of the board meeting. Those are the items that are saved for closed session. So Shannon, I will let you go ahead and answer in a kind of general aspect.
It's going to be very general and very brief.
Cases.
I have seen in proposed decisions, meaning they went before an ALJ and the case is heard on a reinstatement. I have seen it where the ALJ has proposed in their decision that they retake the NCLEX.
Right. Okay, that's as much as we can talk about it. Thank you.
I have a question. I noticed that when I read the documentation that we get, that it's very variable. That sometimes there's lots of information and we know what the discipline is for, and we know about whether there is mitigation, and other times it's almost difficult to even find what the respondent did that got them in trouble. And so I don't know if there's any kind of basic information. Go ahead.
I was going to say that the cases that normally you typically will not see a lot in the cause for discipline is a lot of the cases where we did a mental or physical assessment through the 820 exam. And we are not putting out their medical history in the accusation, simply maybe supplying that they did not pass their 820, as opposed to kind of putting out all of their mental health information. So in those cases, yes, we try, and the attorneys try to, within that letter of recommendation to adopt that comes as the cover to that packet, which is your decision and your proposed decision or your stipulated settlement, and then the pleading, they try to fill in those gaps for you on, you know, what the allegations were, what kind of mitigation they received, why they imposed the discipline, or why the stipulated settlement, and if it deviated from what the standard in the disciplinary guidelines would provide for. So normally in that letter of recommendation to adopt it, they try to fill in all of those gaps for you to help you out with that case. We do know there are times that there's still maybe a few gaps. I think when we're as close to a case sometimes and we come to the end, we already have such a good understanding of it that, you know, to take a step back and say, okay, if I was someone who had no idea about this case, what would I need to know? And maybe sometimes that is lost in that recommendation to adopt, but that's what that letter's for, and that's what we try to do. When we do go to closed session on cases where there have been questions, I try to fill those gaps in for you guys so you have a better understanding. Yeah.
This is Reza. I wanted to also add to that. I think I have kind of an understanding of what you're seeing, Vicky, and why there's some distinction as well. So as you know, you get different types of discipline related things sent to you for consideration. Those include proposed decisions where an administrative law judge has considered the case and written it. Also, you sometimes reject those proposed decisions and you get the entire administrative record. So you might get volumes of transcript and exhibits and stuff like that, in which case you have the whole universe of the administrative record. And then lastly, the stipulations, which might be kind of what you have in mind, where you get a little bit more limited information. And in those situations, it's not gone to hearing, so there is no kind of formal administrative record resulting from a hearing. So yeah, those letters that you get, try to outline at a high level. But one difference with the stipulations, where you do receive a lot less, you don't have a fully written proposed decision where the ALJ has kind of himself or herself highlighted the factual and legal conclusions. With the STIPs, you have the opportunity to discuss in closed session and actually get Shannon to fill in some of the gaps. I wanted to clarify, Shannon said that she can fill in the gaps in closed session, and that's with the stipulations that we do that. On the proposed decisions and everything else, we stick to the administrative record, and Shannon's not even there in closed session for those. But with the stipulations, the respondent has agreed that we can discuss it with, the board can discuss it with board staff, and they have the opportunity then to fill in some of the gaps and things like that that might not be fully kind of fleshed out in the paperwork.
That I actually have figured out, but I would like to avoid having things have to go to closed session. And so it would be helpful if I could just figure out what a respondent did without having to search around for it. So that would be helpful to me.
Maybe that's some feedback Shannon can take to our DAGs who prepare those things. I'm presuming you're talking mostly about the stipulations, where everything else you have quite a bit of material. If the DAGs can kind of enhance what they in there.
On a lot of our out-of-state disciplines, a lot of times within their charging documents from the other state, they don't have a very detailed explanation. So then when we use our code section that authorizes us to take action against the other state's action, we don't have a lot of content to put in there. So that's another scenario in where we may not have as much in-depth cause as you would like to see to kind of give you some inclination of exactly what it was they did.
Yeah, I read dozens of them before I finally figured that part out. So you start figuring it out over time.
But believe me, if we have the content and we're able to put it in there, we put it in there. So if it's not in, there's usually a reason why.
Yeah, I'm kind of getting it.
But Vicki, to your point, I thought that was really important, because some of them actually start out like on the first page, it has a summary. And I'm not sure, those are so helpful, because if you have the summary right there, you're like, boom. And if I want more detail, I can go dig for it. But I wonder, what makes a difference between when one of the cases has a summary right at the beginning versus not one?
So, and I know what the type of cases you're talking about, where there's like a finding of fact, where they give us a scenario of events in chronological order. Those are usually your practice cases where there's been some deviation from medication administration documentation, and it'll say patient A dates with whatever happened, patient B, so on. With those, sometimes you get those, sometimes you get, you'll see where there's a table as opposed to the summary, where they're laying out a table of the medications that were pulled, whether they were documented, wasted appropriately, et cetera. You have numerous DAGs around the state. Everyone has a little different way of writing. If you guys prefer a type of writing, I never want to tell an attorney how to write out their legal documents. But if there's feedback that I can take, I do have meetings with. I have 2 DAG liaisons that I meet with on a monthly basis, and I can take that information back if there's You know, if you would like that findings of fact some more, but those are usually practice cases, and it's usually where there's documentation, and they have to kind of give you a scenario up front. But I have seen that difference too, Mary. I noticed that too.
Yeah, and some of them actually are not that long. It really is even a couple of paragraphs of the summary. So, but those are, to me, those are, I see one of those and like, yes.
Yeah,
Very helpful.
Yeah.
I will let them know that.
Any other questions or comments for Shannon?
No, thank you,
But I
Shannon. This was
wanted to thank you. It was so
Thank you.
helpful.
really helpful.
Welcome.
So real quick, just to put a reminder out there, Shannon did mention that the purpose of this was to look at the enforcement process and related to the disciplinary guidelines. And why that is of utmost importance is we are revising those disciplinary guidelines. It's going to be a very extensive regulatory package that we are hoping to be able to bring to the board the end of this year, if not the beginning of this next year. And so having a understanding, clicking on the disciplinary guidelines, reading through them is going to be of great benefit when it comes time to us to have to present that to you guys as a regulatory package, and present the changes and the reasonings behind that and receive public comment on it. Shannon also did mention that the Nurse Practitioner Advisory Committee, as well as the Nurse Midwife Advisory Committee, will be making some suggested changes there to address some of the independent practice disciplinary guideline and those expanded scopes for the advanced practice RNs. And so just wanted to make sure that I kind of wrap this up, tie it back in, and ensure that there is further focus on this as we move through the year to get ready for that regulatory package. Thank you, guys.
Thank you.
Thank you, Shannon. We need to move out to public comment.
It is an agenda item. It's always good to have public comment for every item, but we do not have to have a vote as this is information only.
Okay, BRN moderator, can you please open it up for public comments?
Public comment now. I will be activating the question and answer feature. Please refer to the screen share for members of the public to see how they should type in the request for comment. I've activated the question and answer feature. Members of the public can indicate that they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." Board President Trujillo, there are no public requests for comment. Would you like me to close this window?
Yes, please. Thank you. So the next item in our agenda, I think we're done with the public portion of the agenda.
We would be
Following
going
a
into
bio break, 15-minute bio break.
I do just want to make an announcement that the link for closed session has been sent to the board members' emails. And that if you guys want to join at 3:15 to start closed session, that'll give you guys 10 minutes for a bio break. I am hearing that it should not take an extensive amount of time to wrap that up.
All
Are we
right.
coming back here to adjourn, or can we leave this meeting?
Reza, I don't believe that this is adjournment. Obviously, this would be a 10-minute recess and then the board members going into public comment, but we could make a decision to close this meeting. That'd be up to you.
What I would suggest, did we do the public comment on the enforcement?
We did, and there was no public comment, so we moved on to this item.
Okay, which is the closed session.
Yeah.
Right. So I think we can essentially, for the benefit of the public, there's not any further discussion or action to be taken in open session. So the board will be taking a brief break and then going into closed session for its discipline items. And then I don't believe we have to come back to WebEx just to announce that the meeting is concluded.
So we
Again,
can
there's
sign
no
up for
business further to be
WebEx.
discussed. So,
Okay. So
Thank
the
you.
public portion of this meeting is adjourned for today. Thank you for attending, and I will see the board in closed session at 3:15.
Thank you. Thank you.
Thank you.